Welcome to our new video. Today, we're going to discuss a very important topic under the Insolvency and Bankruptcy Code. Part 2, Insolvency for Corporate Persons. If you're a student, professional, or just curious about how insolvency works for companies, this video will break it down in simple terms. So let's get started. Part 2, Insolvency for Corporate Persons. Section 4, Application of this part. To initiate an insolvency process for corporate debtors, the default should be at least INR 1 crore. This limit was increased from INR 1 lakh to INR 1 crore via the MCA notification dated 24th March 2020. Section 5 Key Definitions. Under Part 2, Insolvency Resolution and Liquidation for Corporate Persons. 1. Financial creditor means any person to whom a financial debt is owed and includes a person to whom such debt has been legally assigned or transferred. 2. Financial debt means a debt along with interest, if any, which is disbursed against the consideration for the time value of money and includes 3. Operational creditor means a person to whom an operational debt is owed and includes any person to whom such debt has been legally assigned or transferred. 4. Corporate applicant means A. Corporate debtor, or B. A member or partner of the corporate debtor who is authorized to make an application for the corporate insolvency resolution process, or the pre-packaged insolvency resolution process, as the case may be, under the constitutional document of the corporate debtor, or C. An individual who is in charge of managing the operations and resources of the corporate debtor, or D. A person who has the control and supervision over the financial affairs of the corporate debtor. 5. Interim finance means any financial debt raised by the resolution professional during the insolvency resolution process period and such other debt as may be notified. Interim finance can enable the IP to protect and preserve the value of the property of the corporate debtor and manage its operations as a going concern. Interim finance is allowed to form part of CIRP costs. 6. Operational debt means a claim in respect of the provision of goods or services including employment, or a debt in respect of the two of dues arising under any law. A. Money borrowed against the payment of interest. B. Any amount raised by acceptance under any acceptance credit facility or its dematerialized equivalent. C. Issue of bonds, notes, debentures, loan stock, or any similar instrument. D. Amount of any liability in respect of any lease or hire purchase contracts. E. Receivables sold or discounted other than any receivables sold on a non-recourse basis. F. Any amount raised under any other transaction including sale or purchase agreement. G. Any derivative transaction or benefit from the fluctuations in any rate or price for calculative the value of such derivative transaction. Only the market value will be taken. H. Any counter-indemnity obligation in respect of a guarantee, indemnity, bond, documentary letter of credit, or any other instrument issued by a bank or financial institution. I. Amount of liability in respect of guarantee or indemnity of any of the items referred above. 7. Initiation date means the date on which a financial creditor, corporate applicant, or operational creditor, as the case may be, makes an application to the adjudicating authority for initiating the corporate insolvency resolution process. 8. Insolvency commencement date means the date of admission of an application for initiating the corporate insolvency resolution process by the adjudicating authority under Sections 7, 9, and 10, as the case may be. 9. Insolvency resolution process period means the period of 180 days beginning from the insolvency commencement date and ending on 180th day. The Code provides for a time-bound insolvency resolution process for companies and individuals, which is required to be completed within 180 days, subject to a one-time extension by 90 days. However, the process shall mandatorily be completed within a period of 330 days from the insolvency commencement date. 10. Insolvency resolution process costs means any interim financing cost incurred in raising such finance, fees payable to interim resolution professional, or any cost incurred by him in running the business of corporate debtor as going concern, any cost incurred at the expense of Gov.T to facilitate the process, or any other cost as may be specified by the Board, 11. Liquidation cost means any cost incurred by the liquidator during the period of liquidation subject to such regulations as may be specified by the board. 12. Liquidation commencement date means the date on which proceedings for liquidation commence under Section 33 or Section 59, as the case may be. 13. Liquidator means insolvency professional appointed as a liquidator by the provisions of Chapter 3 or Chapter 5 of this part, as the case may be. 14. Resolution applicant means a person who individually or jointly with any other person submits a resolution plan to the resolution professional pursuant the invitation made under Clause H of subsection 2 of Section 25. 15. Resolution plan means a plan proposed by resolution applicant for insolvency resolution of the corporate debtor as a going concern following Part 2. Explanation. For removal of doubts, it is hereby clarified that a resolution plan may include provisions for the restructuring of the corporate debtor, including by way of merger, amalgamation, and demerger. 16. Resolution professional means an insolvency professional appointed to conduct the corporate insolvency resolution process and includes an interim resolution professional. For more detailed information, visit the official website of VMK Professionals, www.vmkprebs.com, and always review the latest amendments before execution, as laws keep changing frequently. Conclusion. Insofar as any legislative can have a transformative effect, the IBC had achieved that objective. The government has been very proactive in ensuring that the problems are dealt with and in a time-bound manner. The IBC has taken its first steps to regularize the insolvency process in India. It has amended over 11 legislations in India, as mentioned above in PG03, bringing about one of the most significant change to commercial laws in India in recent times. It has also become a very important tool for banks to regularize multitudes of non-performing assets, troubling the country's economy. The preamble to the code emphasizes its purpose as timely corporate reorganization and insolvency resolution to maximize asset value. The IBC has brought a plethora of changes to insolvency laws in India and aims to reduce the amount of bad loans that has saddled the economy over the last few years. We are beginning to see this through various companies successfully concluding their insolvency process. The first successful case of a CRC was that of Bhushan Steel, wherein Tata Steel agreed to purchase Bhushan Steel for Rs 32,500 crores. To ensure a formal and time-bound insolvency resolution process, the Code creates a new institutional framework consisting of the Insolvency and Bankruptcy Board of India, IBBI, adjudicating authorities, insolvency professionals, IPs, insolvency professional agencies, IPAs, and information utilities, IUs. This entire insolvency and bankruptcy process is managed by a regulated and licensed professional, namely the insolvency professional, IP, who is appointed by the adjudicator. Section 3 and 5 of Insolvency and Bankruptcy Code, 2016, defines the important terms which will be used in further procedure and sections of Insolvency and Bankruptcy Code. The Insolvency and Bankruptcy Code 2016 consists of total 255 sections organized in 5 parts. The code also has 12 schedules which amends various statutes. All the sections and schedules will be covered in further articles. That's it for this video. We hope you learned something new today about the insolvency process for corporate persons. If you found this helpful, don't forget to like, share, and subscribe to our channel. Also, drop a comment below sharing your thoughts or any questions you have. We'd love to hear your experience or doubts. Thanks for watching, and see you in the next video.